Hi, my name is İlham Rose. I am one of the family law attorneys here at Anal Galant and Partners. A little bit about me, I went to Rutgers Law School in Camden, and I've been practicing exclusively matrimonial matters, which include divorces, child custody cases, child support, domestic violence, some child abuse and neglect cases, and prenuptial and postnuptial agreements. So the answer to that is generally yes, so long as the marriage occurred in a different country and it was considered valid in that country when you got married, and as long as you meet the New Jersey residency requirements, you should be able to get divorced here in New Jersey. The residency requirements in New Jersey for a divorce are you need to be living in New Jersey for at least 1 year prior to filing your complaint for divorce. There are certain exceptions to that, but the general term is 1 year. So the general answer to that question is that it's up to New Jersey to decide whether or not to defer the divorce to another country or whether or not to proceed with the divorce proceedings here in New Jersey. There are a number of factors that a New Jersey court will consider in making its decision. Some of those factors include whether or not New Jersey has jurisdiction over the matter, whether or not the petitioner lives here in New Jersey, and whether or not the petitioner meets the residency requirements here in New Jersey. So essentially, it's discretionary. It's up to a New Jersey court to make that decision whether or not to defer to another country or to proceed here in New Jersey with that divorce. But it's really also up to the party to make a good faith argument to a New Jersey court as to whether or not they have a stronger interest to continue litigating here and have their divorce heard here in New Jersey or not. So the answer to that is, although New Jersey is not required to honor a foreign divorce judgment, it typically will do so long as both parties were afforded due process in that country and they were also afforded the opportunity to represent themselves or have counsel represent them. The foreign court would also have had jurisdiction over the matter. And in order for a New Jersey court to accept that foreign divorce judgment, we have to ensure in New Jersey that the foreign divorce judgment does not offend New Jersey's public policy. The court would also like to ensure that at least one party was residing in the country at the time that the divorce judgment was entered. Yeah, so that's one of the difficulties that we do encounter sometimes when you are trying to serve a person with a divorce complaint. In New Jersey, it's required to serve another party personally, meaning you can't serve them via mail, via email, social media. It has to be done in person. But if you are unable to locate that person, one of the things that we can do is we can request from the court a substituted service, meaning we file a motion for substituted service in which we ask the court to allow us to serve the other party in an alternative method, such as email or mail, or in one particular case, even Facebook, if we know that that party utilizes Facebook quite often. And so long as you show the judge that you've made due diligence and you have made concrete efforts to serve that person in person and you were unable to, the court will generally accept that motion for substituted service and allow you to serve that person in an alternative way. Sure. So if you are seeking a divorce in New Jersey, the first step that you would take is to file a complaint for divorce. That would go ahead and get filed with the court here in New Jersey in the county within you reside. After that is filed, the other party would then get served with that complaint for divorce in person, and they would have 35 days within which to respond to that complaint for divorce. If they do not respond within the 35-day time frame, they would then be in default, and we would go ahead and request for the court to enter default against them. Essentially what that means is that we would request for the court to grant whatever you are requesting, since the other person basically didn't show up and they didn't respond. In the event that the other party does respond to the complaint for divorce within the 35-day time frame, then the court would go ahead and start divorce proceedings. The first step in that case would be to have what's called a case management conference. At that conference, the court would set discovery deadlines, which is essentially a fancy word for evidence. Parties would exchange what's called interrogatories and notice to produce, and they could have a real estate appraisal done. There are a number of things that the court would consider at that case management conference to move your case along. After that, the court would also have what's called an early settlement panel, which is where you have very experienced matrimonial attorneys who will give you recommendations on how your matter should be decided, essentially. It's basically their expertise. They practice in those courts. They'll give you what is their advice, what their recommendations are, and you can take that advice or you could leave it. You could continue on with the divorce proceedings, and that would be the next step, which is economic mediation. And in that time, a mediator, who is a neutral party, would try to assist the parties in settling their case. If that still doesn't work to settle your divorce matter, you would also then mandatorily have to attend what's called an intensive settlement conference. That is an all-day conference at the courthouse where the judge is essentially making one last-ditch effort to get you and your spouse to settle your divorce case. If that still does not work, then you have one last step in your divorce process, and that is to proceed with trial. And that will typically take about a year from the filing of your divorce complaint to get to the point of a trial date being set.